not happy, obviously, with the fact that his client is been remanded into police custody. Hello, good evening, sir. Welcome to Eyewitness News.
Good evening, sir.
Yes, very tall order there. Your client, the accused, is been remanded into police custody, and you also say that the charge against him is shambolic. How do you mean exactly, sir?
Hello, you and I know when it comes to murder, it is not by summary trial. And as such, a matter like this, if you are going to go by indictment, you should be ready. Either you are bringing him to court for committal and not just come to court asking for a remand. Because, a remand, it's quite retrograde these days, and how we just get, people are just put on remand. People are just put on remand without any recourse to the facts and the circumstances, because the provision of the Constitution guarantees a presumption of innocence and not a presumption of guilt. As such, I don't know why when the police prays for a remand, it's always granted. And secondly, the facts are that you say someone has provided pictures to another person to show in a media house. Then subsequently, you turn around and say that you are charging him strictly under Section 46 of the Criminal Offences Act, that's to murder. Where is the nexus between giving pictures and committing the crime of murder? Where is the murder weapon? What was the cause of death, and where is the murder weapon? And where was the suspect or the accused? Was he within the precincts of the murder scene? But all these facts together is what I look at and say that the police just came to throw this charge of murder to make it look so powerful and strong and make it look so compelling that the court would defer to them. Because they've kept him from Saturday, 5 days. And this, if we are computing time properly, so we are looking at, it's going into the 6th day now. So what are we looking at? What couldn't they have asked in the last 5 days? That requires that they have to ask for remand.
I see. Yes. Kofi, but you know the matter of bail is at the discretion of the court, of course, within the parameters of the law. Your client, as we know it, left the country soon after the event. The police said they were looking for him. They couldn't find him. He fled the country. That makes him a flight risk. So if you grant him or admit him to bail, the probability of, he running away is quite high. And so he's a flight risk. Perhaps that was what worked on the judge's mind to grant the police's or the prosecution's, opposition to your bail application.
Thank you, Solomon. I understand it's at the discretion of the court, but bail should not be granted or denied as a form of punishment. Okay, you have not let him out yet for him to jump bail. Secondly, he hasn't been a flight risk since he was presented to court in the first instance. He's been in this country, and not just 2025. He's been doing undercover investigations, and he has published some, shown some on TV and all that, published and even caused people to be arrested and all that. People who are selling very bad, unwholesome foods and unwholesome drugs. He's been in country doing all these undercover investigations. So he is not being on the run. He's been in country for years. So if they are saying they've been trying to reach him and he doesn't come and all that, I don't know where it lies.
Because the accusation is that the accusation is that when the incident occurred, the police invited him. He did not attend to the invitation of the police, and then he fled the country.
For that, I would say that my instructions, when he engaged us, I don't know about any invitations before then. But when they last invited him, we spoke, we called them and said we will come. But we wanted to go as a team of 2 lawyers. One had an emergency, and in the heat of the moment, running and taking the child to the hospital and all that, we couldn't even get back to the police officer. And before I realized, the very next weekend, he was arrested and taken in.
I see.
So yes, those are the facts around why we couldn't honor that invitation. But we're willing. We called them. If they will be candid about it, we called and they said we'll come.
As far back as 2019, when the event occurred?
No. Just 2 weeks ago. We're talking 2 weeks ago. When he came engaging us proper. But I'm saying that 2019, I don't know. I don't know about that. If they say so, then they may have to prove it. How long they've been engaging him.
But your client hasn't told you whether he was invited by the police in 2019 after the incident or not?
I may have to have conference with him to get that.
But do you have plans of repeating the bail application perhaps at the High Court?
We don't want to put all our arsenals out, so let's look at it. We may.
Very well.
Probable. It's highly probable.
Very well. Thanks so much, Kofi SL Esquire, lawyer for the accused Daniel Owusu-Cranton. He has been charged for murder in the case of Ahmed Suale.